On this episode of Law Weekly, we look at the Nigerian Constitution and the recent amendments. We have the views of a senior advocate of Nigeria, Robert Emukwero. Also showing on the program, the International Law Association's Arbitration Committee sets agenda for the country's power sector in the maiden edition of its public sector series, which had the topic, Decentralizing Nigeria's Power Sector. Plus a recap of the major stories from the courts. Hello and welcome to the program. I'm Shola Shieli. In March this year, President Muhammadu Buhari assented to 16 constitution amendment bills sent to him by the National Assembly. Some of the bills he assented to deal with devolution of powers and promote true federalism. They include bills to provide for the financial independence of state houses of assembly and state judiciaries, to move the item railways from the exclusive legislative list to the concurrent legislative list, and to allow states to generate, transmit, and distribute electricity in areas covered by the national grid, among other bills. My guest, Senior Advocate of Nigeria, Robert Emukwero, has been variously described as an accomplished legal practitioner with a flair for reducing complex legal issues into easily digestible nuggets. He was the lead consultant to the Senate Ad Hoc Committee on the alteration of the 1999 Constitution, which produced 44 far-reaching proposals, 16 of which have now been signed by the President and have become part and parcel of the Constitution. He also served on the Electoral Committee of the National Assembly, which saw to the enactment of the much-celebrated Electoral Act 2022. I started with his views on the circumstances under which the alteration of the Constitution was achieved.
The background to the Constitution review exercise of the Ninth Assembly really cannot be stated without first and foremost highlighting the difficulties that we had. The whole exercise started during the COVID period, so for many months we could hardly sit or do anything. We were meant to start around February of 2020. This was during the height of COVID. So some of the things we did, really we didn't do anything until the whole COVID virus issue subsided, and then we gradually started to do something in 2021. And then we ran into the problem of funding the exercise. After some time we picked up, and then we had public hearings throughout the 6 geopolitical zones, and it was quite interesting. The response was massive response. People really were interested in this constitutional review exercise, and it showed that Nigerians were very anxious to really improve on this present constitution, which, as you remember, is really a gift from a military regime. So that agitation to make it reflective of our democratic experience was huge, and that largely guided our work. Somewhere along the line, we started first, that is the Senate. It took the House of Representatives a bit of some time for them to pick up their act, but when they did, they went into overdrive. And at some point, the two arms of the National Assembly came together, set up a committee, a joint committee, and we were able to come up with some very interesting proposals for amendment of the Constitution, and happily, they passed about 44. I know the women's bill didn't scale through at the floor of the National Assembly. It's generated a lot of outcry. There were some that were so innocuous that I thought ordinarily should pass, but I think they just wholesale rejected the women's bill because they really didn't understand some of them, and painted them with the brush of one very controversial one, which had to do with more or less assigning specific number of seats for women at the National Assembly. That wasn't what most of these bills were all about. That was just a standalone bill. If they didn't want that, they could have rejected that and looked dispassionately at others that wanted to remedy issues about married women who marry from different states and what is their status. Because some women, they've had challenges within the federal establishment. Once you marry to another state, the state have
can't take up appointments in another state where you've served.
honestly speaking, from that state. Even the state that you have left to, they don't see you favorably and all of that. So there were amendments to address specifically this particular problem women were facing.
As consultant to the lawmakers, what role would you say that you and the other consultants played, especially when you say that there was ignorance on the part of the lawmakers about some of these bills?
So as lead consultant to the Senate on this constitutional review exercise, our interaction was really largely with the committee of the Senate itself, headed by the Office of the Deputy Senate President, Senator Ovio Omabege. And the committee of the Senate had about 57 members of that committee. So the role of the consultants, of which I was the lead consultant, was largely to advise these committees of the Senate on the proposals that we received from members of the public, proposals that the senators themselves generated, and then previous proposals that had failed for one reason or the other. So we had three sets of things we had to look at. The first were new proposals from the public that came in through the public hearing. The other was proposals from senators generated themselves, which had in fact gone through first and second reading, and then previous proposals of the 8th Assembly that failed at different stages. Some failed at the National Assembly, some failed at the point of the State's House of Assembly, and others failed at the point of presidential access. So we considered all the bills together and advised them on, one, the format or the form that the bills themselves should take, and some that simply really couldn't pass muster for one reason or the other. So we really didn't have any direct interaction with the National Assembly when they sat in plenary to vote. We were not there. And you know, the committee of the Senate now merged with the committee of the House of Representatives to try to harmonize the bills that was, the proposals from both arms of the National Assembly at a joint sitting that lasted for about maybe 4 or 5 days in Abuja. And they came out with a report. So it is that report of that joint committee of the National Assembly that the plenary now debated and voted on. So of course, most of the members of the plenary were not privy to a lot of these discussions, but ordinarily one would have thought that they will follow the lead of their committee, but they didn't. They voted the way they just simply wanted to vote. There is a particular bill that I thought was really quite important, and that had to do with the proposal to establish a federal revenue court. You know, originally, the idea of the Federal High Court, it started as a federal revenue court because there was a need to create a court that dealt exclusively with federal revenue. That is the revenue of the federal government and then the revenue of the federation itself. So that this court is not a court that is overwhelmed with normal, ordinary cases. So in its original concept, the original concept of the Federal High Court was to be a federal revenue court that dealt exclusively and only with issues of revenue when it started. But I think it was through Decree 107 that was passed under Abacha's regime, sometime in 1993 or thereabout, that the jurisdiction of the Federal High Court was expanded to cover issues of maritime and so many other things that, strictly speaking, were not issues of federal revenue. Now, when the 1999 Constitution came into, there have been expansion of the jurisdiction of the Federal High Court to the point now that the Federal High Court is almost like a political court. Under this present Electoral Act, all pre-election matters are taken to the Federal High Court.
Meaning that we've further expanded Section 251?
Yes, it's been further expanded because the Section 251 itself anticipates that the national, or allows the National Assembly to increase the jurisdiction of the Federal High Court by adding to its jurisdiction, which the National Assembly has done several times, increasing the jurisdiction of the Federal High Court. So the Federal High Court, as it is now, has lost its character as a Federal Revenue Court. And even the Federal Inland Revenue, I know they are groaning. Their cases are not making, there's no priority to the case of the Federal Inland Revenue anymore. And also even the Revenue Mobilization, Allocation and Fiscal Commission is unable to perform some of its constitutional functions effectively because they are bogged down by litigation in the Federal High Court. So this was what inspired the idea of creating a Federal Revenue Court that was in conception to be restored to its original status of being a court established solely and exclusively to deal with matters of revenue, both at the federal level and then for states that desire it. So this was one of the proposals that I thought really addressed a major issue of revenue.
What exactly happened with the aviation bill?
Of course, the issue of aviation too, a lot of work went into that, and I ordinarily had thought that that was a very innocuous bill, just to give what I would call constitutional backing to a state of affairs that is already existing, namely that there are private airports that are being operated in Nigeria. MMA2 is a private airport. It's not owned by government. Delta State has an airport. Akwa Ibom, these are not government operated. Or Osubi Airport is also a private airport. So the idea behind moving aviation from the exclusive to the concurrent list was not to detract from the regulatory oversight of the federal government. Even with that movement, the complete oversight still remained with the federal government exclusively. So it is just a very small and narrow aspect of the business operation of it that is now left for the states to look into. That is all. It didn't affect any international treaty. It didn't affect anything at all.
Well, at which stage did that one die?
Well, that had passed the National Assembly. It had also met the two-thirds requirement of the state. That is, the two-thirds of the states of the Federation had passed it. It failed at the point of the president signing.
Let's round up with talking about the innovations on the Electoral Act. I know you did some work in that regard too, but what impact would you say that they had on the elections?
Well, yes, I was involved in the technical committee of the joint committee of the National Assembly. That's the Senate and the House of Representatives that enacted or at least pushed for the enactment of this 2022 Electoral Act. And I think the significant innovation was really the introduction of technology into the Electoral Act. And let me just give you a brief background on why it was necessary to put that in. You know, when the INEC introduced the smart card reader, it came by way of their guidelines and regulations. Supreme Court in a series of cases that, look, you cannot use INEC regulation and guidelines to introduce this kind of innovation for you to say you want to use it as a basis to challenge the outcome of an election, that it must be in the act. So that resolution was taken at, look, we must have technology in the Electoral Act as the means of accreditation. Mode of voting should be as prescribed by INEC itself. So there was really no express provision for electronic voting, but the provision prohibiting electronic voting was deleted outrightly in this current provision. So there is no provision saying electronic voting is prohibited. It's been deleted. In fact, there is a provision saying you may vote electronically as prescribed by INEC. So this is the major innovation in the Electoral Act. And of course, the other innovation too is supposed to deal with the issue of post-election litigation. Because of the challenges that petitioners, persons who are complaining about how the elections were conducted, encounter improving their case, a particular provision was provided to more or less ameliorate the huge burden They carry improving issues relating to non-compliance only. Corrupt practices being criminal, you have to still prove it beyond reasonable doubt. But with regard to non-compliance that are manifest, for example, a man says a polling unit result was not signed. Surely you don't need anybody to tell you that. You can see it's not signed. This is a non-compliance. But what impact will this non-compliance have on the result of the election is a completely different kettle of fish. Now let us go back to the innovations that are meant for the conduct of the election itself, which is how INEC brought in the beavers, the bimodal voter accreditation system. It's purely for accreditation. It has nothing to do with voting. Now, the impact this had on the election is that the kind of bogus figures that you see in election was completely eliminated at this election. Because accreditation now is recorded and everybody can see what it is on the beavers. It can be uploaded real time almost immediately. So to inflate figures is really very difficult now. So that's why you see many elections, you don't see huge figures anymore. So that is certainly one impact it had in the election.
Welcome back. The International Law Association's Arbitration Committee has held the first edition of its public sector series, which had the topic, Decentralizing Nigeria's Power Sector. It was a virtual event which attracted players in the power sector. Experts on the panel used the opportunity to set an agenda for the country's power sector. Via the fifth alteration to the 1999 Constitution, one of the bills the President signed into law ensured the devolution of powers to state governments in the area of electricity. With this amendment, state governments can now make laws on areas covered by the national grid. The first speaker at the ILA's Arbitration Committee's Public Sector Series, Mr. Abiodun Aikomo, was a member of the drafting committee who advised the President on the amendment. He shares the intention behind this amendment.
This is a departure from what we used to have, because the states were only allowed to do so in areas not covered by the national grid. And this is as a result of the government's commitment to deal with the problem of electricity supply in Nigeria. There is a serious correlation between development and electricity availability in any society. And the government of Nigeria has historically tried to provide electricity in abundance to the citizens, but we are not where we are supposed to be yet. So this is yet another step in the right direction to ensure that electricity supply is improved.
The second speaker, Mrs. Jumoke Delano, dwelt on issues beyond energy access, the need for investments in the sector, issues of regulation, rent-seeking, and more.
In terms of the way forward, my recommendation would be collaboration. There is a need for collaboration between the stakeholders in order to create clarity on the rights and responsibilities, of the federal and the state, players, even in the electricity market. There's an important need for collaboration between the federal regulator, which is the Nigerian Electricity and Regulatory Commission, and the states in formulating the policies, in formulating the laws, that, these states are going to enact.
For the chairman of the Arbitration Committee of the ILA, Tolu Aderemi, he says there's a need to look at the Electricity Power Sector Act, review the National Electricity Policy, and ultimately develop the electricity supply industry along regional lines.
So I think essentially our work is cut out for us. I think the federal government, which is, I commend them for this initiative. It is what is important. And the states must know the implication of this for them. I think this is very important. If nothing at all, the states must start thinking that, look, every state must understand the Abba geometric power model. That's exactly what we are going to be dealing with now. The state must understand that they are to run a complete power value chain, starting from power generation to collection. And I think ultimately the state government must start coming together to work towards developing a regional master plan.
A former Commissioner of Water Resources and Energy in Plateau State, Engineer Jafar Owuyep, says his state is prepared to take advantage of the new amendments. He also believes that there is a need to have frank conversations between the federal, states, and other stakeholders as to how best to move forward. Let's now check out some of the top stories we tracked at the court.
We begin with the report that the president-elect Bola Tinubu is challenging the right of the Labour Party's candidate Peter Obi to challenge his victory at the February 25th presidential election. In his response to the petition by Obi and the Labour Party, the president-elect argues that Peter Obi was not a lawful member of the party as at the time he contested on the party's platform and lacks the locus standi to challenge the outcome of the election. His team of lawyers led by Wale Olanikwekun added that as at 24th May 2022, 6 days before the primary election of the Labour Party purportedly held to elect Obi as the presidential candidate of the party for the presidential election held on February 25th, 2023, Peter Obi was still a card-carrying member of the People's Democratic Party and did not resign his membership of the said party until May the 24th, 2022. They also argued that the grounds on which the petition is predicated are incompetent, thereby denying the court the needed jurisdiction. They also argued that the claim by Obi and his party that Tinubu was not qualified to contest the election was outside the issue the court could deal with because it falls within the precinct of pre-election issues. The lawyers also faulted Obi's claim, insisting that Tinubu was never convicted. They pointed out that Obi did not disclose any facts showing that within a period of less than 10 years before the date of the election to the office of the president, Tinubu had been sentenced for an offense involving dishonesty or had been found guilty of the contravention of the Code of Conduct. Staying with the same petition, the Independent National Electoral Commission INEC, who is also a respondent, has asked the Presidential Election Petition Tribunal to dismiss it. INEC said the relief sought by Obi and his party are not grantable. The Commission asked the court to either dismiss or strike out the petition for being grossly incompetent, abusive, vague, non-specific, ambiguous and academic. INEC further discredited the petitioners over the claim that Tinubu was not elected by the majority of lawful votes cast. They argued that the petitioners' prayer to declare that Obi scored the majority of lawful votes cast at the election and be declared winner was defective for failure to join necessary parties and for lack of requisite particulars to support same. The Commission said Obi cannot be returned as elected, having not polled majority of the lawful votes cast at the election and secured 1/4 of the votes cast at the election in each of at least 2/3 of all states in the Federation and the FCT. On the issue of non-representation, INEC said the petitioners did not have polling agents in all the polling units across Nigeria, as they only submitted a list of 134,874 polling agents, which are 41,972 short of the 176,846 polling units across Nigeria. The petitioners had asserted that the election was marred by rigging and manipulations, adding that the INEC violated its own regulations when it announced the results, when at the time of the announcement the total polling unit results had yet to be fully scanned, uploaded and transmitted electronically as required by the Electoral Act. The same INEC says the presidential candidate of the People's Democratic Party, Atiku Abubakar, did not meet the constitutional requirements to be declared winner of the February 25th election. Urging the presidential election petition court to dismiss the petition by Atiku and his party, the Commission said Atiku failed to score at least 1/4 of the votes cast in at least 2/3 of the 36 states of the Federation and the Federal Capital Territory, and as such could not have been declared the winner. As against the claim by the petitioners, INEC adds that the election was conducted in substantial compliance with the Electoral Act 2022 and was not marred by any corrupt practices. The Commission insisted that the President-elect Bola Ahmed Tinubu validly won the election. The Commission also said the APC candidate met all the legal requirements to be so announced as the winner. The candidate of the PDP on his part has asked the Code of Conduct Bureau (CCB) to drop its investigation into the petition brought against their client by the Minister of State for Labour and Employment, Mr. Festus Keyamo. Keyamo had in his petition to the CCB called for Atiku's probe for allegedly using a special purpose vehicle to divert public funds between 1999 and 2007 when he was vice president. In a letter written to the CCB, the lead counsel, Mr. Michael Zekome, notes that the matter is sub judice as Mr. Keyamo had filed the same matter at the Federal High Court, Abuja. He says it is highly inappropriate for a party to a suit to take an extrajudicial step or to embark on any course of action that is either tantamount to or calculated to undermine the authority and integrity of the court. He then urged the Bureau to refrain from interfering in the subject matter of Mr. Keyamo's petition and to advise and direct him to pursue his pending litigation against Mr. Atiku Abubakar to its logical conclusion. And we round up with the report that petitioners have also gone to court to challenge various governorship elections. In Kano State, the All Progressives Congress has filed a petition before the Governorship Election Petition Tribunal challenging the declaration of Abba Kabir Yusuf of the New Nigeria People's Party as winner of the March 18, 2023 governorship poll. According to the APC, Yusuf was not qualified to contest the election as his name was not on the list of members of the NNPP submitted to the Independent National Electoral Commission. The party also alleged that the NNPP did not win the election with the majority of lawful votes, claiming that some of the votes cast for them were invalid. In Lagos, the tribunal has received 4 petitions challenging the return of Governor Babajide Sanwo-Olu and his deputy Obafemi Hamzat. Those who filed are the People's Democratic Party and its candidate Abdulaziz Adediran, as well as the Labour Party governorship candidate Gbadebo Rhodesviver, who filed as the sole petitioner. Others are the Allied People's Movement and the Action People's Party.
And that's our program this week. Thank you very much for watching. Be sure to catch the repeat on air or watch via our YouTube channel. I'm Shola Shirley. Thank you for watching and see you next week.